there is a very interesting trick or issue to be discussed from the legal point of view and from a practical point of view for you as well, that how this agreement, this kind of agreement are executed. I mean, when you want to lease an apartment, you want to print out the rent agreement or lease agreement, we call it, and you want to sit down and sign it, okay? I mean, if you buy a property, you want to sign a deed, or if you want to, I don't know, you name it, you print out the document and you sign it, both parties. Could be both taken on one table, would be faxed or scanned an email, whatever, but the basic way of executing this agreement is by signing the agreement. So one particular thing that we have in these kind of agreements, usually or most of the cases, is that there is not going to be this print out and the signing execution. There's one issue to be discussed or analyzed that is new because of the technology development. It's going to be accepted by clicking on the internet. I mean, one company is going to upload the software, the licensor, and the licensee is going to accept or execute in a broader way of using the word execution and agreement by clicking on the internet. So this clicking means that the licensee executed the agreement or accepted the terms made, the famous terms and conditions when you read the certificate. That's an agreement, even though you don't see it that way. That one means like a proposal and acceptance. In this case, the licensor proposes and the licensee accepts the terms and conditions that constitute the agreement. Okay? So they want to speak a little bit about this, whether this is valid, this is not valid. If it's valid, I mean it is less strong than a traditional printout agreement. Then another issue to be usually is addressed is another thing that is new, I mean for this compared to the traditional agreement, is where, and this is important from the legal point of view, where is the performance of the agreement will take place. Okay, when we talk about the lease agreement, this is where the property is located. If you want to build a factory where the factory is located, I mean, you know the performance. Where you want to be talking about the loan agreement is where the disbursement will be made. But here, I mean, you have one guy or one company in Nebraska, there is the licensor. You can have another company in Singapore that is the licensee clicking. So where is the performance? So usually, you want to listen to me to say a lot the word usually, because we are talking about agreements, we are not talking about law. So, because I'm happy with the student that you say, it's like this, and they say, no, I read an agreement, but no. Usually because it's an agreement, I mean, most of the agreement will be this way, but it could happen that you read something different, okay? Usually, the agreement will say that the parties agree that the performance of the agreement will be at the licensor main office country. And this is very important because of which will be the law to be applied in case of in event of conflict. Okay, that has the legal consequences where the agreement will take place and the execution of it. And then law enforcement licensor main office country, that's what is again usually stated in this kind of agreement. Why? Because the strong part in this agreement is the licensor, because it's the one that is going to upload your agreement. It's not that you're going to negotiate with the licensor if you are the licensee. So the licensee will be, we can say, the weak part of the agreement. So if you're a strong part, you want to have, in case of conflict, that the court of your country, of your city, to participate in the dispute, and that this agreement be interpreted under the laws of my agreement, of my country. Let me tell you something maybe you don't know. You can have an agreement be subject to one country court and be interpreted by the law of another country. It's not that common, and it's pretty weird that you're going to see that because you're going to have the judge from one country applying the law of another country. But it's legally possible. could be a case, for instance, that you trust New York law or New York state law, but the company that you are negotiating with is from New York, and you don't want a judge from this jurisdiction. But both parties trust that law. So they say, we both trust this law because we trust that this law is not going to change in the future, like in Argentina, if a law that change, I mean, this is not trustful. But you trust the law, but you don't want to have a judge of this jurisdiction to be used in case of conflict. Again, it's not that common, but I have to say to you, 90 or 95% of the cases you're going to have the law and the court or jurisdiction being the same. But let me tell you, because many people used to think that it have to be that way. If you have to be that way, you will have an agreement mentioning both things. And if you are familiar in translating an agreement, you're going to remember that usually you're going to say, this agreement will be constructed under the law of that country, X. UK, stop. Another sentence. In case of conflict, this agreement will be subject to jurisdiction in United Kingdom courts. So it's not redundant. You see what I mean? It is because you can have one court of one country and the other. Again, it's not common. I want to make this clarification. Okay? Really, stop. You're not a court. There are no videos. It's not that fun as I told you guys. I mean, if you are shy, it's your problem. I speak. The lawyer speaks. Don't worry. Tell me 1 more hour, I speak 1 more hour. Yeah.
So let's say, based on your example, if I am in Europe and I buy an American software and it's subject to the Nebraska law, for example, when I'm not satisfied with the services I have gotten, or the service or the software crash, and
you have a legal issue.
Can I go to a European court, or do I have to apply to a Nebraska court if I live in Europe?
You have to go to Nebraska.
Oh, great. So I'm screwed both ways.
No, we are not screwed. I mean, we are in a worse off position that is what the licensor wants. You see what I mean?
Yeah.
You are not screwed. I mean, you are in a worse off position. That's true. I mean, it's cheaper, easier for you to litigate in your country. You pick up the phone, you go to the lawyer, maybe you pay a monthly fee or whatever, and you say, I want to make a lawsuit to this company. It's pretty quick and cheap. Imagine you have to get a lawyer in Nebraska. They ask you for a retainer because they don't know you, and I mean, it's true. I mean, send me first money, then you want to think about it. Then you have a cost, you are not close, it's a different, language, culture, country. So, but you have to choose one jurisdiction, you cannot choose two. This is why I'm going to try to speak a little more about arbitration. That is usually the way these problems are solved. Because let's say this is not this kind of agreement that I write and you click. We are negotiating. You're going to say, I'm not going to Nebraska. I'm going to say, I'm not going to Europe. So that's it. We're going to make a huge business, from a commercial point of view, but we're not going to do it because we're not going to get in the court jurisdiction. It doesn't make sense, you know what I mean? So this is what you have arbitration, that is what I talk later, that usually is a way of solving this deadlock problem, because if you want Europe and I want Europe, you can't do it. I mean, if you want Paris and I want Nebraska, that's it. You know, when I convince me that you go France, Paris and Nebraska, you see what I mean? That's it.